Yes, first of all, we have to take into account the sovereign immunity and international law of asset confiscation. It's quite vague. Why sovereign immunity refers to principle that a state is protected from being sued in a foreign court or having assets seized without its consent. The principle is enshrined with both customary international law and various multinational and multilateral treaties, including United Nations Convention of Jurisdictional Immunities of States and Their Property from 2004. The EU potential role to confiscate frozen Russian assets may be really legally complex in this context, as such actions could violate sovereign immunity. If we take into account the Vienna Convention of Diplomatic Relations from 1961, we will see that there is a very strong protection of diplomatic and consular property and funds of foreign states, which is reinforced the nation that the foreign governments assets should generally be immune from seizure. On the other hand, the UN Convention of Jurisdictional Immunities of the State, it's a treaty which has already established the framework of sovereign immunity, which allows for certain exceptions. In this extent, for instance, involving commercial transaction or in cases related to human rights violation. However, the treaty has not been that widely ratified, particularly by countries like US. And thus this application might be really debated in this particular state. We have to take into account as well that the key exception which can apply in a Russian asset are the commercial exceptions. Because under the international law, sovereign immunity does not apply when the state engages in commercial activities. And if frozen Russian assets are connected in any way to this commercial activities, they might be a subject of seizure by EU. The exception might be particularly relevant in the case of assets held by Russian government in foreign financial institution or commercial enterprises abroad. That's the reason why this is the narrow but the path to move. Additionally, violation of international law could as well provide the grounds of suspension of sovereign immunity. In this context, EU actions may be justified under the principle of international law if the confiscation of the redirection of assets is framed as response to Russian violation of international humanitarian law or its role in ongoing work against Ukraine. Moreover, International Court of Justice, ICJ, could as well become a venue of adjudicating the issue. The ICJ role would likely focus on whether EU actions against Russia violate its rights under the sovereign immunity principle or not necessarily. This will actually allow to give a response of violation or not of international treaties or a war crime. Another thing is legal precedents and the global sanctions, because US and Western precedents actually show that, for instance, US has imposed sanctions under the Foreign Sovereign Immunities Act, FSAI, which allows a seizure of asset in the case of state-sponsored terrorism or violation of international law. And through EU legal system, we can see that maybe there are not such aggressive application, but there are as well quite similar measures. For instance, United States, in the context of the United States versus metric tons of oil in 1981, your legal case where the seizure of asset, in this case oil, or Kuwait Airways Corporation versus Iraq in 1994, there was U.S. Court of Appeal which actually stated that the invasion of Kuwait was the reason why the sovereign immunity does not apply when states commit violation of international law. In this case, it was aggression and war crimes, of course. When European Court of Justice will come into the theater as well as a let's say judicial force and as a wise man, prudent, as we say in French, this might be really important way to assess is the confiscation of assets were contested in the EU legal framework or not. Because we have to take into account that European Court of Justice, in different than British or American way of law being stated, has as well right to actually make a quite, let's say, final assessment of the law. And if we take into account that the cession of sovereign assets will have to be closely, of course, aligned with EU sanctions regime, so we will have here, let's say, a watchdog as well, who will play a role of ensuring that this quite narrow path between what is permissible and
Yes.
what is an interpretation could be
Well,
taken. And I
Mr.
think that
Swen
actually European
yes. Well,
Court of
Mr.
Justice would
Swenson,
do it.